Hey y'all, it's Kim again. So this is another court case or pending litigation, whatever, against Jeffrey Epstein and some of the co-conspirators, Haley Robson and Sarah Kellen, as defendants. This is United States District Court, and it's only 8 pages, so I want to get through this one, and now I can get it off my screen because I got so many documents pulled up. Anyway, Southern District of Florida, number 08080804. I guess it's a civil case. Myra versus or slash Johnson, something like that. Jane Doe, aka Jane Doe number one, plaintiff, versus Jeffrey Epstein, Haley Robson, and Sarah Kalen, defendants. So those are some of the girls that helped traffic these girls along with Ghislaine. Anyway, it says opinion and order remanding case to state court. This cause is before the court on plaintiff's motion to remand DE 11, filed August 18th, 2008. Defendants filed a response, DE 21, and plaintiff subsequently replied, DE 22. The motion is now fully briefed and is ripe for review. The court has carefully reviewed all of the briefs and the entire record and is otherwise advised in the background or in the process. I'm sorry, in the premise. I'm sorry, I screwed that up. So the background, plaintiff Jane Doe, aka Jane Doe number one, filed a 4-count complaint in the circuit court of the 15th Judicial Circuit in Fort Palm Beach County, Florida on June 25th, 2008, bringing actions for sexual assault against defendant Jeffrey Epstein and civil conspiracy, intentional infliction of emotional distress, and civil remedy for violation of Florida statute section 772.103 against all three defendants, DE1. The facts as alleged in the complaint are as follows. At all relevant times, Epstein was an adult male. Epstein engaged in a plan, scheme, and or enterprise in which he gained access to primarily economically disadvantaged minor girls in his home, sexually assaulted these girls or coerced or attempted to coerce them to engage in prostitution, and then gave them money. In or about 2005, plaintiff, then 14 years old, became a victim of this scheme. Defendant Sarah Kellen here, and then Haley Robson recruited girls ostensibly to give a wealthy man a massage for monetary compensation in his Palm Beach mansion. Under the plan, Robson was contacted shortly before or soon after Epstein was at his Palm Beach residence. Epstein, Kellen, and someone in or on their behalf directed Robson to bring one or more underage girls to the residence. Robson generally sought out economically disadvantaged underage girls from Loxahatchee and surrounding areas. Upon arrival at Epstein's mansion, Robson would introduce each victim to Kellen, who gathered the girl's personal information. Defendant Kellen would then bring the girl up a flight of stairs to a bedroom that contained a massage table, the pink stairs. If you go back in the videos, there's a tour of Epstein's Palm Beach mansion, just so you know. And then Kellen would then leave the girl alone in the room, whereupon Epstein would enter wearing only a towel. Epstein would then remove his towel, lay down naked on the massage table, and direct the girl to remove her clothes. Epstein would then perform one or more lewd, lascivious, and sexual acts, including masturbation, touching the girl's vagina with the vibrator, or digitally penetrating the girl's vagina, and coerce or attempt to coerce the girl to engage in either lewd acts or prostitution or both. Consistent with the foregoing plan, Robson recruited plaintiff to give Epstein a massage for monetary compensation. Robson brought plaintiff to Epstein's mansion in Palm Beach. Plaintiff was introduced to Kellen, who led her up the stairs to the room with the massage table. Kellen set up the massage table, laid out the massage rolls, told plaintiff that Epstein would be in shortly and then left the room. Plaintiff was alone in the room when Epstein arrived. Epstein told her to remove her clothes and left the room. Epstein returned wearing only a towel. Epstein removed his towel and laid down on his stomach on the massage table. Epstein again told plaintiff to remove her clothes. In shock, fear, and trepidation, plaintiff complied, removing her clothes except for her panties and bra. Shortly after starting to rub Epstein's back, Epstein told plaintiff to sit on his back. Plaintiff, out of fear and trepidation, complied. After a period of time, Epstein got up from the table and went behind the door. For several minutes, plaintiff heard loud noises and moans and believed that Epstein was masturbating. I think I've read this one before, but this may be another version of it. Okay, thereafter, Epstein naked returned to the massage table and laid face up on the table. Epstein then told plaintiff to continue with the massage and told her to sit on top of him. Out of fear and trepidation, she complied. As plaintiff rubbed Epstein's chest, Epstein began to use a vibrator on plaintiff's vagina. Oh, gorgeous. Thereafter, Epstein began to digitally stimulate and attempt to penetrate plaintiff's vagina. At this same time, Epstein was masturbating. Upon reaching orgasm, Epstein got up from the massage table, told plaintiff to write down her name and phone number, and then left the room. Plaintiff was then able to get dressed, leave the room, and go back downstairs into the kitchen. Epstein, Robson, and Kellen were waiting for plaintiff. Epstein paid plaintiff $300. Epstein paid Robson $200 for bringing the plaintiff to him. Robson took plaintiff home. As a result of this encounter, the 14-year-old plaintiff experienced confusion, shame, humiliation, and embarrassment, and the assault sent her life into a downward spiral. Defendants filed a notice of removal with this court on July 18, 2008, DE1. Defendants assert that this court has jurisdiction pursuant to 28 U.S.C. subsection 1332. The amount in controversy exceeds $75,000. Defendant Epstein is a U.S. citizen of the U.S. Virgin Islands, and defendant Sarah Kellen is a citizen of New York. Notice of removal, whatever. As plaintiff is a citizen of Florida, complete diversity exists, and this court's jurisdiction is allowed to be or alleged to be proper. As for Haley Robson, defendant claims that Robson was fraudulently joined to defeat diversity jurisdiction. Notice of removal, and then plaintiffs have moved to remand the action, claiming that Robson was not fraudulently joined to this action. As such, plaintiff asserts that complete diversity does not exist, and this court does not have jurisdiction over this case. Standard of review: a defendant may remove any civil action brought in a state court over which a federal court would also have original jurisdiction, 28 U.S.C. subsection 1441A. However, the burden of establishing federal jurisdiction under subsection 1441 rests with the parties seeking removal. So let's see, Carson versus Dunham, 121 U.S. 421, 425. And this is 1887. Diaz versus Shepard, 85 F3D, 1502, 1505, 11th Circuit, 1996. The right of removal is strictly construed as it is considered a federal infringement on a state's power to adjudicate disputes in its own courts. See Shamrock Oil and Gas Corp versus Sheets, 313 U.S. 100, 108-09 in 1941. Thus, when the court's jurisdiction over a case is doubtful, doubts are resolved in favor of remand. See Crow versus Coleman, 113, F3D, 1536, 1539, 11th Circuit, 1997. Discussion: the fraudulent joinder. A defendant's statutory rights of removal cannot be defeated by a fraudulent joinder of a resident defendant having no real connection with the controversy. Wilson versus Republic Iron and Steel Company, 257 U.S. 9297, 1921. Thus, courts have established the doctrine of fraudulent joinder to allow the removal of a case to federal court despite the presence of a non-diverse or foreign citizen defendant. The 11th Circuit has provided substantial guidance for the district court in situations where a party removes a case from state court alleging fraudulent joinder of the non-diverse parties. In a removal case alleging fraudulent joinder, the removing party has the burden of proving that either there is no possibility that the plaintiff can establish a cause of action against the resident defendant, or the plaintiff has fraudulently pled jurisdictional facts to bring the resident defendant into the state court. The burden of the removing party is a heavy one. To determine whether the case should be remanded, the district court must evaluate the factual allegations in the light most favorable to the plaintiff and must resolve any uncertainties about state substantive law in favor of the plaintiff. Crow 113 F3D at 1538. In this case, defendants do not allege that plaintiff fraudulently pled jurisdictional facts. Instead, defendants argue that plaintiff has no cause of action against Robson. The amended complaint alleges 3 causes of action against Robson: civil conspiracy, count 2, intentional infliction of emotional distress, count 3, and civil remedy for violation of Florida state or statute section 772.103, count 4. The court, in considering the remand motion, must not weigh the merits of a plaintiff's claim beyond determining whether any of the alleged causes of action is an arguable one under state law. See Crow 113 F3D 1538. If there is even a possibility that a state court could find that the complaint states a cause of action against any one of the resident defendants, the federal court must find the joinder was proper and remand the case to state court. Quoting Coker versus Amoco Oil, 709F.2D, 1433, 1440, 1441, 11th Circuit, 1983. The Florida 5th District Court of Appeals set forth the elements of a civil conspiracy as follows. The elements of a civil conspiracy are a conspiracy between 2 or more parties to do an unlawful act or to do a lawful act by unlawful means, the doing of some overt act in pursuance of the conspiracy, and damage to plaintiff as a result of the acts performed pursuant to the conspiracy. Walters versus Blankenship, 931, SO.2D, 137140, and I guess it's Florida. I don't know what this one is. Oh, probably the 5th District Court of Appeals in 2006. Citing Florida Fern Growers Association, Inc. versus Concerned Citizens of Putnam County, 616 SO2D 562. And then I guess it's Florida 5th District Court of Appeals, 1993. Here, plaintiff has alleged each of the required elements in her amended complaint as follows: a conspiracy between the 3 defendants, including Robson, to do an unlawful act that is committed to commit the tort of sexual assault of a minor. Robson committed an overt act in pursuance of the conspiracy, that is, Robson used false pretenses to lure plaintiff to Epstein's home so that Epstein could sexually assault plaintiff, and severe and permanent traumatic injuries, including mental, psychological, and emotional damages. Additionally, an actionable conspiracy requires an actionable underlying tort or wrong. Ramey versus Furlong, 702 SO.2D, 1273, 1284, and I guess there'll be like the 3rd District Court of Appeals, 1997. And then also see Walters 931 S.2D at 141. The gist of a civil action for conspiracy is not the conspiracy itself, but the civil wrong which is done pursuant to the conspiracy and which results in damage to the plaintiff, citations omitted. Thus, a cause of action for civil conspiracy exists only if the basis for the conspiracy is an independent wrong or tort, which would constitute a cause of action if the wrong were done by one person. Rivers versus Dillard's Department Store, Inc., quoting Black versus Green, Rose, Kahn, and Piotrkowski. The alleged underlying wrong or tort in this case is sexual assault of a 14-year-old minor. Sexual assault is considered tortious conduct under Florida law. Malicki versus Doe. See also Doe versus Celebrity Cruises, Inc. Florida law equates sexual battery with an intentional tort. At the very least, plaintiff's complaint states a cause of action for the underlying tort of battery, as a 14-year-old cannot consent to the alleged vaginal penetration by Epstein, Florida statute subsection 800.04. Based on the foregoing, the court cannot say with certainty that no possibility exists that plaintiff can establish a cause of action against the resident Robson in state court. See Crow in 1538. As such, the court concludes the defendants have not met their heavy burden of demonstrating that joinder of the claims against Robson was fraudulent, justifying denial of the motion to remand. Conclusion: accordingly, it is hereby ordered and adjudged as follows. Plaintiff's motions to remand is granted. This case shall be remanded to the Circuit Court for the 15th Judicial Circuit in and for Palm Beach County, Florida. Case number 502008, CA 006596, for lack of subject matter jurisdiction. The clerk of this court is hereby directed to forward a certified copy of this order to the clerk of the Circuit Court for the 15th Judicial Court in and for Palm Beach County, Florida. Case number 502008, CA 006596. All pending motions are hereby denied without prejudice as moot, and this case is closed. Done and ordered in chambers at West Palm Beach, County, Florida, this third day of October 2008. Kenneth A. Mara. Copies furnished to all counsel of record. So I guess they were trying to basically exclude that girl from, well, the Robson from being involved in this case because where she lived. I think that's what they were trying to say here. That's whatever. It doesn't matter. They're all trying to cover their butts at this point. But yes. Anyway, I'll see y'all later. Have a good afternoon. See ya. Bye.